Hey guys, Colleen here with the English Law Group, and I wanted to go over the NAR proposed settlement, the key terms, the key things that you need to know, and the things that we don't know, because there is a lot that we don't know right now. So I'm going to go over those things. I did teach a class, and I'll be teaching future classes on this, but in all honesty, more will be revealed. The class went a little bit long, so I'm going to try to rein it in and keep it on a pretty good time frame here of going over all of these elements, and that should equip you enough to at least be able to answer some questions from clients. And at the end of the day, we're going to have to keep, it's pretty fluid, so we're all trying to figure things out right now. So I am going to share my screen, and okay, so sorry. Okay, so this the entire settlement agreement is extremely long, and really the meat and the potatoes of what most agents are concerned with, the real estate industry is talking about, those things that the news is kind of going nuts over, is paragraph 58. All the things I'm going to be talking about, most of which are in paragraph 58, they will expire in 7 years. That being said, if a requirement takes, if we're 7 years from now, the real estate industry shifts and changes so much. But by the time that all of these requirements are expired, I would imagine that there's going to be a whole new way of doing things. But at the same time, I don't foresee there being quite as many changes as everybody anticipates. So there's going to be some big changes, but I think overall, people are going to be surprised at the end of the day how much doesn't change. So this is the National Association of Realtors proposed settlement, and it is not approved by the DOJ yet, but the Department of Justice, but most likely they will accept it. Usually when a plaintiff and a defendant get together and they come up with a settlement as exhaustive as this, usually the judge kind of thinks, okay, well, if both parties are happy, then we're good to go. So there could be some tweaks, there could be some changes, but I would imagine the bare bones of this, most of it is probably going to be implemented. There's no crystal ball, but that's just my prediction. Proposed does mean that it has not been accepted yet. This is not the law as of yet, but this is just the proposal. And it could take months for this proposal to be accepted by the court. However, most of the things within the settlement say that they will begin in July. I think it's a good idea to go ahead and have it ready to go in July, maybe start using some of these practices now, because most of the things that are part of this you can do right now. And a lot of it we're already doing. It's just that the way it was presented by the plaintiffs, the people bringing the case, it sounded like there weren't. And that's why the judgment was in favor of the plaintiffs. So the key terms, basically, it releases from the parties of the settlement against any future liability as long as you adhere to the terms of the settlement. So as long as the settlement is approved and you adhere to these things, then you cannot be brought into court on the same matters. This counts for 1 million NAR members, but it doesn't include home services. There were a couple of plaintiffs. NAR could only tackle this one spot, and it covers state and territorial associations, the MLSs, and any brokerage whose volume of residential transactions was less than $2 billion in 2022. So that is a vast, huge number of realtors in the United States. So it's going to cover quite a few people, and it will cover our local associations here in the Louisville area, Southern Indiana, and it's going to affect a lot of people. So at the end of the day, NAR continues to deny all wrongdoings. Part of the reason that they want the settlement is so that they can say, look, we weren't doing anything wrong. There's clearly some issues that people have with what we were doing, so we will change things and we will pay you a lot of money, but we are not going to admit that anything that we have or have ever done was incorrect. And that's important for them to be able to say that. And for you guys to be able to say that there really wasn't, we're not admitting that we're wrong, but clearly people have issues with what's going on. And so we're going to change some of our practices. So that's part of the settlement. So the settlement, NAR is going to pay $118 million over approximately 4 years. And that is better than the $1.8 billion judgment. So this is a lot better. And they do promise that for 2024, they are not going to raise the dues. They've not said anything about anybody any other time, but they're going to have to get the money somewhere. So that's just the way that that goes. And $418 million is a lot of money, but not as much as it could have been. So that's part of the reason for the settlement. So a lot of people are really upset with NAR right now. And they're like, you know what? You're supposed to be representing us. We feel like we didn't get a fair shake on this. You're throwing the whole real estate industry upside down. Why would you do this to us? We feel betrayed. Okay, so here's the deal. They lost big time. They lost, and it did not take a jury any time at all to figure out, unprecedented amount of time to figure out that they lost. So it wasn't even close. There are 10 copycat cases right now that have already been filed. I believe it's 10, in all different jurisdictions. So basically, at the end of the day, the lawyers are going to win. They could get sued in every jurisdiction if they did not put an end to it. So this stops the bleeding, and they couldn't just say, okay, we're done, we'll pay this. They would have to appeal, and an appeal could take years, and they would have to appeal in different jurisdictions. So this thing could be taken forever. It had already been 3 years, I think, that the whole thing's been going on. So this is really honestly the better way. It stops the bleeding. They say 118 million. We know what that is, and we will start paying it. They can set up a payment plan, and they don't have any future lawsuits that they don't know about that they're going to now have to litigate. So it is a really big deal. Plus, had they just lost and they just said, you know what, we're done, they would most likely have had to have filed bankruptcy. And if you file bankruptcy, it would be a Chapter 11, excuse me. And if they do that, then they would actually not be able to be a part of changing any of the policies and procedures. Because basically they would be like, you know what, I'm out. I can't pay anything. So you know what, you can't be a player in it either. So it is important. They could have saved some money, I guess, with the Chapter 11 or the Chapter 11 bankruptcy, but it is extremely important that they are a part of this negotiation, because they, better than anyone, know what it's like to practice, to be a realtor. So they are using those things rather than just letting some judge come on and say, okay, this is the way you need to run your industry, which is just horrible when that usually happens. So this is actually the better way. So love it or hate it, that's where we are. So the one thing I want to make clear is that the news is saying that cooperating commissions are gone. You will no longer have to pay a buyer side commission. And that is just not true. Numerous places throughout the settlement, and I have read the whole settlement, they have said that we still think it's a good idea. It's still great. A lot of buyers still need this, and it will actually help the lower income, less savvy buyers in being able to have their commissions paid for by sellers. Because the truth is, a lot of buyers don't have the liquid cash to pay it. And a lot of loans, the way that they're written and the requirements now, do not even allow borrowers to pay commissions. So for example, the VA loan. The VA loan does not allow, as of today, the VA loan does not allow a buyer to pay the commission or admin fee or anything like that for their realtor. So there has been, I'm a member of the Veterans Association of Real Estate Professionals, and they are HUD approved educators. They are the masters in the field when it comes to the VA loan. And they have said that they are not going to give an opinion at all of what any of this means, because they're waiting for the VA to tell them. They're waiting for the VA to tell them if there's any changes. FHA mortgages are government backed too. So there are a lot of things that we are waiting for. There might be underwriting change requirements. There might be ways that buyers can bundle their commissions into their loan, but they're not, those things are not there today. So I will say that there are a lot of unknowns, especially when it comes to someone borrowing money and being allowed to pay commissions. With a conventional loan, you can pay whatever commissions you want. With cash, obviously, you can pay whatever you want. But there are some loans that prohibit that. And so we're going to have to learn how to address those things. So the first thing, okay, so I'm still on this slide. All right, so the cooperating commissions are not gone. And there was a claim by the plaintiffs that said that agents were saying that cooperating commissions were required, that they had to do cooperating commissions. That was never true. That has never been true. And that's always been an option, but it has not been a requirement. So they're just saying part of the settlement says, you know what, they aren't required. You know, they never said they were required, but sure, they're not required. Okay, we'll say it, as we've always said. And one thing it does do, though, that is going to be a little tricky and could actually cause some discriminatory practices, is that it prohibits the requirement that cooperating commissions, if made, be blanket, conditional, and unilateral. Now, I think the reason that they're doing that is that, let's say, and any percentages I'm using right now are just at random. I'm not saying that there's typical commissions, because that's another issue that was brought up, but and that's always been a big thing with antitrust violations. So let's say that an agent offers 2.5% as a cooperating commission, and they get, you know, over asking price, but the other agent says, seller, I would like you to pay me 3%. That agent, because, you know, maybe because, okay, well, look, we got the sales price we want, you know, all right, this was easy. You know what, I'll just give them part of my cooperating commission, a little bit more than I had agreed upon. I'll give them 3%. Seller, you don't have to bring any more money to they don't have to take any more money out of your proceeds. They can do that. They can do that now. So that's one of the things that they're requiring of the settlement. If it comes in, you get this lowball offer, and it's, you know, you're like, oh my gosh, this is crazy. But the seller's like, you know what, we'll go with it. You could say, all right, in this case, I'm sticking with the 2.5% that I already offered you. So see, they're not the same, but that is allowable because you can take it based on what is being offered, and you can negotiate. So you can negotiate. You've always been able to negotiate, but it was really, you know, this clearly states that you can change what the cooperating commission is. So we need to be really, really careful, though, that we do that in a way that is only numbers based, if that is something that ever comes up. Or you could just say, you know what, I'm never going to change it. Like that's you know, you can't do that, but in practice that can be what happens, because you can't prohibit, you know, that you're able to negotiate with things, because that's a whole thing, is that they want these commissions to be negotiable. That's the listing side, the buyer side, the cooperating, all of it's negotiable. So that means that one offer might look a little different for the cooperating commission than the other offer, and the listing agent gets to choose, you know. So there you go. All right. So one of the major changes that everyone is really, really nervous about is that you cannot put a cooperating commission on the MLS. That does not mean that cooperating commissions are gone. Commercial agents, they have to, they don't have it listed anywhere what their cooperating commission is going to be. They have to ask the seller, and usually the seller pays it. Most of the time, cooperating commissions on any type of a transaction are going to come out of the seller's proceeds, because the seller's the one that it has the cash. They have the money to do it. So you can't, they're going to remove the field they're from the MLS, and you can't put any code words and any notes or anything like that, like wink, wink, you know, whatever, because people were searching properties based on commissions, and that is a bad thing. They shouldn't do that. I wish they would have just taken out the ability to do that. I think that could have solved a lot of problems, but all commissions are negotiable. By not having them on the MLS, they want you to present all offers to your clients. That's what you're supposed to be doing. The reality is a lot of people weren't doing that. And so that's part of the problem. So because of that, now they're going to make it that it's completely unsearchable and not even allowable on any MLS or anything that any other database or product that MLS puts out. You can't put that kind of stuff anywhere. So they are gonna, it's gonna be prohibited on the MLS, but it doesn't mean that the sellers can't offer it. If you do say that anything on the MLS, if you say my seller is willing to pay $10,000 in buyer's concessions to be used however buyer wants, okay, that could be for commissions, that could be for prepaids and closing costs, that could be for points, that could be for anything. You can't condition it on being paid for an agent. So you don't have an agent, then my client gets more money. You can't do that. So it has to be the same across the board. Let's see, you can and then they get, again, they say that offers of compensation could continue to be an option consumers can pursue off the MLS through negotiations. So okay, so can a third party create an alternative to MLS to post compensation? The MLS, they've clearly stated within the settlement that the MLS cannot take all this information and dump it into another portal where they can then circumvent these rules, and then it's all for naught. So the MLS can't do that. NAR cannot promote that, but there's nothing to say that some other third party can't do that. And people take advantage of things. So I would imagine that that might be a possibility later on. Now, would they be brought into a lawsuit? Maybe, but there could be some other entity, some other third party that takes advantage of this, and they really, become a huge player in a game that they're not bound by this. But just that being said, there's also that you can, as an agent on your own brokerage website, you can post your listings and put what your cooperating commission is on your listings. You cannot share anybody else's listings that have said what the cooperating commission is. So what I would anticipate is there might be a lot of people that, they come up with a list of properties for their clients, and before going, they look and they see, okay, well, let's go on ABC Realtors website. Okay, they're offering this. So now I know that this is what we need to ask. You're gonna have to know what the cooperating commission is before you write an offer, because it is going to be extremely important to find out if your client needs to pay it, or if you need to ask the seller, or if you need to ask for a little bit more from the seller. So this is all this stuff. So you also can't say, you can't say our ABC office, always offers 3%, because that would be antitrust violation, or 2.5%, or whatever percentage. There's been a question, can you create like an a la carte services? Well, that's actually on a different thing. So anyway, if it's your own listing and your own brokerage, you can put that on there. So I've also heard that people are going to probably use showing time to put it on there, because Zillow owns showing times, that it's not owned by MLS. I don't think there's an issue with that. Now, I could be completely shut down with that. So just take that for what it is. There is a lot of stuff that we're going to find out whether or not it's kosher, whether or not it's okay. So, there's going to be a lot of ideas for different things popping around. So, we're going to get a lot more guidance. I can tell you that there's going to be a lot more guidance by our local MLSs. Okay. So this is something that a lot of people do not know. This is the code of ethics by the National Association of Realtors, 16-16. Okay, I'm going to read it because a lot of people don't know this. All right. Acting as subagents or buyers, representatives, or brokers shall not use the terms of an offer to purchase to attempt to modify the listing broker's offer of compensation to subagents or buyer representatives or brokers, nor make the submission of an executed offer to purchase contingent on listing broker's agreement to modify the offer of compensation. And I've added the emphasis. So the deal, you cannot, in the contract, ask the listing broker to change their cooperating commission. I'll say it again. You cannot, within the contract, the purchase contract, pull in the listing broker and say, hey, I want you to increase my cooperating commission to 3.5. You can't do it. What you can do is this. Except for the fact you cannot make an offer to purchase contingent upon your increase in compensation paid to you by the listing broker, you can negotiate your commission with the listing broker at any time during the transactions. Standard of practice 16-16, which I just read, is designated to protect sellers and listing brokers from having purchase offers held hostage by cooperating brokers demanding higher commission to be paid by the listing broker. Doesn't say anything about the seller, by the listing broker, okay? The standard of practice never prohibits negotiations between the listing broker and cooperating broker at any time during the transaction. In fact, standard of practice 3-3 expressly authorizes the listing broker and cooperating broker to come to an agreement to change cooperative compensations, and that can happen before a property is shown, after a showing, or even after the offer is accepted. I have heard, I can't even tell you how many times agents have told me that they are not allowed to talk to the other agent about the cooperating commission. Hogwash. That is not right. That is not true. You can talk to them about it at any time. You just cannot say you will change my cooperating commission in the contract. You can ask the seller to pay more commission, but you can't pull that listing agent in and tell them to change that. So another part of the settlement that we're going to talk a little bit more about how you would do this is written buyer's agreements. So before you even tour a property, you will have to have an executed written buyer's agreement. Of all of the changes, I think most of them are going to stick, but this is the one that's not going away. They've been talking about it for years. So you're going to have to get buyer agreements signed, and I would highly recommend that you use the local MLS. GLAR has one that they've just updated, which actually is going to change a little bit because it's in violation of some of this stuff, but use the one that you're allowed to use. There are so many changes going on. Stick with what your MLS tells you you can use. Don't go and deviate from it. Don't create your own form. There's a lot of forms that people have that are fantastic, but on this one, it's too big of a cost. Okay, so let's just stick with what we're allowed to use. In Indiana, the governor actually just enacted legislation saying on the 18th of March, saying that effective July 2024, every realtor, every real estate agent in the state of Indiana is going to have a written buyer's agreement. It's a big deal. Okay. So then what do you do? Okay. So we talked about how you can't pull in the listing commission and modify it. So what do you do? All right. So within the purchase contract, this is how you can ask for more money. Okay, so let's say that you've told your client, I would like to be paid 3%. And what we're going to do is we're going to ask the seller to pay for it. And on any house that we look at, I'm expected to be paid 3%. If the cooperating commission is 3%, awesome. We don't need to do anything else. Okay, but let's say that the cooperating commission is only 2.5. And you have a written agreement that says that the seller or the buyer is going to pay 3% if it's not offered to you. All right. So you can put something like this. Buyer's broker shall receive 3% commission for the sale, broken down as follows: 2.5 cooperating commission. And that is assuming that that is what has been offered. Okay. Because you can't change what's been offered from the other agent. Okay. So they've already told you that they're going to give you 2.5. So here you go. You're just reiterating that. The other 0.5% additional commission paid by seller as concessions. That's fine because you are increasing what the seller is paying, not increasing what the listing agent is offering. A bad form of that would be listing agents shall increase cooperating commission to 3%. Cannot do it. Absolutely not. That has always been a violation. You can't, or you could just take what they're offering and then see if you can work with the other agent on the back end and be like, hey, I'm going to be amazing. Da, 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 da. Would you think about maybe giving me this? They don't have to, but that's an offer. And I do think that the settlement statement is going to look the same. I've had a lot of questions of how's it going to be disclosed, da, 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 da. Either way, at the end of the day, it might be that you have the, like, let's say the example of the first bullet, you might have 2.5% and then put another 5.5%, or if it's just a blanket, dollar amount, it could be there, but it will come. I think it's going to come out of the seller side. I could be wrong, but that's what I think is going to happen. It's just going to look the same. Okay. So, it can't be open-ended. So part of the settlement says that you can't, within that buyer's agreement, just say, I'll accept whatever the seller offers. You can't do that. Even though you don't know what is going to come, you have to say, I want this percentage, I want this dollar amount, or I will work for this many hours, blah, blah, blah. You can do a, an a la carte thing if you want. You could say for 1%, I will do da, 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 for 2%, but it is, at the end of the day, if the seller doesn't pay it, the buyer is agreeing to pay it. I've already been asked a couple of different ways that you could disclose this, that maybe they don't feel so bad about it and stuff. And we'll just have to see what kind of guidance we get on that. So it may be that you could say, seller, buyer agent's going to get 3%. However, if seller is only offering 2%, buyer will get 2%. Maybe that, or, buyer's agent, maybe that's okay. But the clear cut rule is, you put down on that agreement what you plan to get paid. It is an app. The buyer's agreement is at will. Okay. It says it's binding, and it is, but you can fire your client and your client can fire you. That's my opinion. Part of the GLAR contract will actually have to be amended, because when they put out this new agreement, it wasn't in light of these new rules. So one of the things it says is, let's say again with the 2, let's say that you've said you want 3%, but all that is cooperating commission is being offered is 2.5%. Or no, I'm sorry, back up. Sorry, complete opposite, rewind. Let's say that you've said you want 2.5%, because that's the only thing the buyer feels comfortable signing and agreeing to. Okay. Then if you go show a listing and the cooperating commission is 3%, you can only take 2.5%. You are not allowed to share it with the buyer, split it, keep it, whatever. The way that the GLAR contract for buyers is right now, it says that if it's in excess of what you've agreed upon, how will you do it? And you can't do that. It's basically, if you haven't asked for it, if you have not contracted for it, then you're not going to get it. And then I've also been asked, how enforceable is this thing? What do we even do if somebody goes behind our back and enters into a contract? So there could be still procuring cause, even if they fire you. You can't, though, I don't think, the way that the broker's lien is written right now, there is a lien out there for brokers. If you didn't know, it's KRS 376.075. And you can do that if you have a contract with someone and it is against, and the person is the owner of the property. The buyer is currently not the owner. And I don't know that even if they became the owner, since when you contracted with them, they weren't the owner. I don't know if that's too much of a stretch. We'll have to get some clarification on that one as well. But the way that it's written, I believe the intention was for listing agents. I don't think that they made that law with the intention of a buyer's agent coming in and putting a lien on something. So anyway, that's just a sidebar. Okay. Right. So anyway, we said that you can't accept anything more than what is agreed upon. So that's that. You cannot say that your commission is free. If you tell a borrower or a buyer or whatever that your commission is free because it's a cooperating commission paid by the other agent, then you're not going to get paid anything. The only time your commission is free is if your commission really is free and you are not accepting anything. You must say that commissions are not set by law. All of our contracts say that. So apparently there's some places where people were not, it wasn't clearly written there. But it's always said that. Maybe some people didn't read it. And then you have to get the seller's permission as a listing agent to offer a cooperating commission. I would think that that would be understood, but the seller has to be aware. I mean, it's pretty clear on the thing. But anyway, so you have to you have to get the seller's permission in writing. Okay, so what does this really mean? The honest answer is we don't really 100% know because it has not been accepted yet by the court. But what it does mean is that, to me, I think, and I think most people that we talk about, is that the way that agents do listing presentations, they're going to have to start doing buyer presentations like that. You're going to have to get a contract. You're going to have to be able to accurately, clearly, and compellingly explain to a buyer why they need you. The contracts, because there's such a wide variety of things that you can do for your agent, the contracts are very, very sparse with making a list of anything that the selling agent is doing. So I've seen some really nice flyers, some really good things. Do not say that you're going to help them with a loan, though, unless you are actually, a licensed lender. Be careful with what some of the things that you say, because you don't want to make it come across that you're licensed to do things that you're not. But there are so many things that agents bring to the table. And I think that we have really watered that down by saying that, well, the buyer's agent's free. Why wouldn't you get an agent? There's so much more than that. So it is going to be a shift in explaining things. And I don't, and the thing is that if somebody is adamant about not paying a cooperating commission, the people that are really going to get hurt are those people that need an agent more than anyone. The people that don't have the cash to bring to closing to pay an agent. The people that have to do 100, have to do 3.5% down, or some sort of down payment assistance, or anything like that. The people that aren't savvy and don't have wads of cash in order to pay, or people that don't want to pay PMI, but now you're dipping into the 20% and you're going to be paying that on a conventional loan. I think it is imperative that listing agents, even though you're not the buyer on that one, we've got to advise our sellers that, look, this is really not different. These fees have been built into the sales price since day one, since the 90s, for the buyer side. And while the media loves to say that everything's changing, because that everybody will watch that, I think that it is an opportunity to hone your skills, to be good at marketing yourself, to put yourself ahead of everybody else. And if you have a lot of years of experience, to really let that shine. If you're new and you're going to do all these other things, to let that shine. Just come up with what your narrative is going to be. And negotiating commissions will probably be more common. But you know what? I was talking to some agents earlier today, and that might not be a bad thing either. So before, when somebody, let's say that you planned on getting paid 2.5% and all that was being offered was 2%, no one would ever ask for another 0.5%, ever. At least not on residential in the area where I am. Not very often, at least. And if they were, it was kind of like, wow, gosh, but you should be. You should be, because you've earned it. And it's not fair. Nobody else works for free. So I think that those are the big things. Education, making sure that you are compliant, but really educating the public as to what's going on. Because at the end of the day, we are responsible to clarify, to set things straight, and to keep going. Because you know what? That's what the real estate industry does, rolls with the punches and reinvents itself and does, picks itself up, and, it's constantly changing. And this is just something else. And it might be that we're like, gosh, this is so much better. So if you have questions, let me know. I'm sure there's a million of them. I can share my PowerPoint presentation with you if you would like. And as we do learn more, I will be doing more and more of these videos. So stay tuned and like my YouTube station. Thanks.